Hello, and welcome to our webinar looking at the changes to charity law. My name is Tracy Bird, and I run the SCVO Trustee Network, which is sponsored by Rathbones, one of the leading charity investment managers in the UK, and whose support enables us to offer these free sessions to our members. So thank you all for coming along today. And we've got really good turnout for today. So while people are still joining us, do take the time to introduce yourselves in the chat. And if you've got any questions that you'd like to ask about the upcoming changes to charity law, put them in the chat as well. And we will have time to look at them as we go through. Just to note, we're recording this session. So if you've got any potentially difficult issues that you'd like to discuss with us and would rather not do that here, then you can get in touch with afterwards and we can set up either a one-to-one session with myself or my colleague Rhonda or a referral to our pro bono service. Also, we will send out all the slides to you afterwards and links to further resources in a follow-up email. So I'm delighted to be joined today by Gillian Harkness McKinlay, who is a director at Anderson Strathern. They're one of the partners in SCVO's free legal advice service, and Gillian is a trustee herself and has been a source of great information and advice to both me, Rhonda, and the SCVO Information Service and our members for many years. So because we've got a lot to get through, and I think we might have a lot of questions, so do keep them coming. I'm now just going to hand over to Gillian for a presentation.
Thanks, Tracy. I'm going to get my apologies in early, everyone. I've got a horrendous hacking cough, so you might want to turn the volume down on your headsets. And my other apology is, and Tracy is well aware of this, I am utterly useless with technology. So every time she asks me to do one of these, she regrets her life choices. I'm going to try now and share my screen. So fingers crossed, everyone, because I'm always an absolute omni-shambles at this. Right, Tracy, I'm relying on you to tell me that I have thankfully done this correctly and that you should be seeing slides coming up somewhere.
Yeah, that's slide number 1 there, and that's all we can see. Yeah, it's worked first time.
And that's all you can see. Oh, success. If I do nothing else right, I've got that right. Thanks so much, everyone, for giving up your lunch break to come and listen to this. I have been a charities solicitor for many years, as Tracy says. I absolutely love being a charities lawyer and hope to do so for many more years. I'm passionate about working with the third sector, but no amount of passion or enthusiasm is necessarily going to make this the most engaging session in the world. It is a bit dry and techy, but it is nonetheless very, very important. So thank you for coming along to inform yourselves on what we're doing. So we're going to start by looking at a bit of the background to the reform, a wee bit on the timetable for the changes coming into effect, and then we will just do a deep dive into the detail of the changes. So the background, I don't know if any of you have been watching One Day on Netflix, which although, excuse me, I'm massively time poor, I've managed to watch for the third time late at night, and then I'm going to inflict on my husband as well. I read the book 2009 when it came out, so the slightly disappointing 2011 adaptation of it. And at that point in time, I saw it very much as a love story. But watching it now, I'm struck very much by the themes of nostalgia and the passage of time in the book, which I found slightly alarming as I've watched the television adaptation. If you don't know it, it starts at the University of Edinburgh. I did not go to Edinburgh Uni, but I spent my days as a bright-eyed and bushy-tailed trainee solicitor in Edinburgh, so it reminds me very much of that time. And when I was a trainee, gasp, there was no Oscar. There was no Charity and Trustee Investment Scotland Act 2005, which is the absolute Bible for charity lawyers. If you wanted charitable status, it was all dealt with by what was called the Inland Revenue, not even HMRC charities south of the border. And the legislation didn't come in until just when I qualified into this world of third sector. And much as I hate to admit it, that was a long time ago. And that's been part of the impetus for reform. 2005 is now a bit of a dim and distant memory. And it's Oscar really who've been pushing for reform of charity law. They went to the government with various suggestions, and that followed a period of consultation. Some of you may have been involved in the consultation process, wasn't entirely ideal in that some of it was done at the height of COVID. I don't know if anyone from Oscar is here on the call, but if they are, I think they'll forgive me for saying that the reforms that have come out of the consultation process are probably regarded a bit as an Oscar wish list. That's not a criticism per se, because as we'll see, the reforms, they make sense. They are useful, and Oscar's key aim was all about maintaining public confidence in the charity sector. So the key themes underpinning most of the reforms that we'll see to charity law are about increasing transparency and accountability in charities. And I have absolutely no issue with that whatsoever. Those are very laudable objectives. But I think what some in and around the sector felt was, where are the reforms that help the sector, that actually support the sector itself? And I'll mention some of those at the end. So I don't have any particular issues or concerns with what is included in the reforms, just a bit of disappointment around what's maybe not included. Something to say right at the outset is the charity test has remained the same. There are two strands to that. The list of charitable purposes, you can only have charitable purposes, and that you have to deliver public benefit. So if anybody was hoping for certain sections of the third sector to have their charity status revoked because you maybe don't entirely believe that they ought to be charities, that's not what this is about. The other element which remains unchanged are charity trustee duties. If you are yourselves charity trustees and if your governance is shipshape, you will all have had at least one and hopefully fairly regular training sessions on your trustee duties. Those remain unchanged. So the timetable for reform. What happened on, sorry, I can't get this to move at the moment. What happened on the back of the consultation was that we got the very snappily named Charities Regulation and Administration Scotland Act 2023. It's a complete mouthful, so I'm going to call it the Amending Act. In terms of charity law reform, we are not getting rid of what I call the Charity Law Bible, the 2005 Act. It's going to remain. All that's happening is this 2023 legislation is going to amend the 2005 Act. So this 2023 Amending Act is really a point in time thing. It will amend the 2005 Act, and once all the changes are in force, you can ignore that 2023 Act. Everything will be in the 2025 Act. And as of Friday, excuse me, last week, we found out the timetable for when the various changes are coming into effect. So actually the bulk of them are coming in on the 1st of April this year. There are a few more coming in the 1st of October this year. And then the remainder, we don't have a definitive date for them, but it's likely to be summer 2025. And these are some of the bulkier changes. And the reason why they're not coming into force until 2025 is twofold. Number one, Oscar need to set up their infrastructure in terms of IT and changes to the Scottish Charity Register to allow for some of these changes that are coming in. And the second reason is on these bulkier reforms, to allow yourselves, to allow charities time to get up to speed and make the necessary arrangements for the changes. With the bulk of the changes coming in on April this year, which is coming around very fast, I think it's March at the end of this week, if you've got applications in train that haven't been determined by Oscar by the 1st of April, they'll then fall to be determined under the new legislation. So I'll give you an example. Bizarrely, at the moment, as things currently stand, if you want to set up a charity in Scotland and represent yourself as a charity, that's fine. You can do that. You apply to Oscar. But come the 1st of April, you will need to have some sort of tangible connection with Scotland. You would think that would be there already, but it's not. And Oscar will be able to refuse applications for charities that really don't have some sort of tangible connection to Scotland. So if you were setting up a new charity now, you've got your application in. As of today, the 28th of February, if Oscar haven't come back by the 1st of April, it will then be the new regime that will determine your application. So it's predominantly a 3-stage process of implementation, but the 1st of April, excuse me, is the first big date we need to be thinking of. Right, we're going to do a deep dive into the techie detail of this, which gets charity lawyers all nerdy and geeky and delighted, but probably not thrilling for the rest of you. I'm not going into, excuse me, every single change. I've tried to group the changes around a topic. And one of the main ones relates to information on charity trustees. And more of this is going to be published and publicly available. So come summer next year, there will be a publicly searchable database. It'll be on the Scottish Charity Register who all of your charity trustees are. That is not currently there. At the moment, all you have to do is, when first applying for charitable status, tell Oscar who each of the charity trustees are. Those charity trustees will change over time, and currently there is no requirement to tell Oscar who the new charity trustees are, that any of the trustees have retired. You will now be legally obliged to tell them every time there are changes in the trustees. And what will show in the Scottish Charity Register is a list of the names of those trustees. Oscar will have a sort of secret database, as it were, sitting behind the scenes showing more information that's not publicly available. So the addresses, the occupations, etc., of those charity trustees. And I think this change makes sense. The public should be able to access information on who is in control of a charity. It helps Oscar with their regulatory regime as well. Undoubtedly, there is more admin involved for charities, but for those of you who come from charitable companies, you should already be used to this because you're legally obliged to notify a company's house every time your directors change. Not that
Gillian, can I just say,
everyone always does it when they're meant to.
Sorry, Gillian, would you mind turning off your camera?
Yep.
Just because it's quite difficult to hear you at certain points. I think it's something wrong with your bandwidth. Thank you. See if that improves things. Thanks.
Okay. Hopefully it would be better now. So yeah, if you're a charitable company, you're already used to the requirement to notify Companies House of changes in directors. So this should be familiar to you, but as a charitable company, you're doubling up then. You're having to notify Companies House and having to notify Oscar. And for other charitable legal forms like SCVOs, unincorporated associations, this will be a new one for you. I was actually thinking the other day, although I'm sure Oscar and the Scottish Government would not thank me for saying so, but in some respects, it would have been helpful to extend this out to members of charities, because if I had £1 for every time I've had charities saying to me, we don't have members, we've just got a board. If you are a SCVO, if you're a company, probably if you're on an unincorporated association as well, you will always have members and a separate board, albeit they might in practical terms be one and the same people, and lack of knowledge as to who the members are can cause issues. I was doing a members voluntary liquidation recently, and there was a bit of a head scratching to find out who the members are, and that's really key information when you're passing the statutory resolution. So maybe one for the future. And a final point to note is there can be exceptional circumstances where you can ask for information on the names of charity trustees not to apply in the register. So that's where there are concerns around the personal security and safety of trustees. I've seen this sort of stuff done under company law before. There was a charity which involved on its board victims of abuse and a victim who had written a book under a pseudonym. And it was seen to be very important to preserve the anonymity of those trustees. So there's scope for doing that. So that is all coming in from summer next year to give Oscar time to gear up the register for information on charity trustees, to give you time to get used to the idea that you will have to notify them of every change in charity trustees. But from October this year, there's going to be another publicly accessible database, which is a database of those individuals who've been removed as charity trustees where there's been misconduct. So they've been removed by the Court of Session. We don't have a current equivalent under the 2005 Act. Again, it's all about increasing transparency and accountability. I think this is a really, really useful one. More and more charities are doing quite broad recruitment exercises, and this just helps you to ensure that you're getting the best people onto your board, or certainly not anyone where there are some major red flags. I was involved in one recently where there was someone who they'd been removed from office in terms of senior management in another jurisdiction, but ended up getting onto the board of a charity. And had that charity been able to access some of that information, it would have really helped with their governance and they wouldn't have gotten themselves in quite a sticky situation. So that's coming from October this year. So there's not anything for you to do. It's something more to be aware of if you're doing recruitment exercises for trustees. So that was additional information around who the charity trustees are. The next one relates to accounts and the publication of accounts. Again, if you're from a charitable company, you'll be very used to the idea that your accounts are publicly available via Companies House. And if I'm acting in a charity merger situation, that is the first thing I look at, where it's two companies. I go in Companies House, I get copies of accounts of the transferor, of the recipient, I see what all the assets and liabilities are, can actually help make a judgment as to which body should be the continuing entity and which should be the one that transfers its assets and winds up. But you can't do that for other charity legal forms. You cannot find the accounts online for SCVOs, and increasingly charities are SCVOs. Can't find it for unincorporated associations. There is some minimal information on Oscar's website, on the Scottish Charity Register, on the finances of charities. But now your full accounts, along with a statement from your auditor or your independent examiner, will be there as well. So you're already having to prepare these accounts and submit them to Oscar within 9 months of your financial year end. There's just this additional stage now that Oscar will publicise those. As with the information they publicise on charity trustees, you can apply to have, say, information on the names of the trustees, which typically appears in your accounts, to be withheld if there are concerns around individual safety and security. And that coming in from summer next year. But what's coming in from the 1st of April this year is a new power for Oscar to remove from the Scottish Charity Register charities that are failing to submit their accounts within that 9-month period after the financial year end, and more crucially, charities that just fail to engage with Oscar on this. So there have been times where there is actually quite a valid reason why a charity is overdue with their accounts and they're struggling to get them in. Increasingly trouble finding people to act as an auditor for ones that need audited, a real dearth of people prepared to do that. The key thing here is that if you've missed the deadline and if Oscar has reached out to you and reached out to you and reached out to you and you're just stonewalling them and don't explain to them why there's a delay or work with them to rectify things, they can then give notice that you will be removed from the Scottish Charity Register, that your charitable status will be revoked. You've got a 3-month grace period to explain to them why this has happened. And this one should really be a particular concern to SCVOs. So if you're a charitable company or a charitable trust, if you lose your charitable status, yeah, that's pretty drastic, but you still exist as a legal entity. If a SCVO loses its charitable status, a SCVO ceases to exist. I don't think, though, this is one to be overly concerned about, as long as your contact details with Oscar are up to date. There was a bit of a horror show one previously, not to do with submission of accounts per se, but the contact details weren't up to date, and Oscar kept trying to get in touch with someone who I think had sadly passed away, and the details had never been updated. So as long as they have up-to-date details, and if you have a genuine issue with submitting your accounts on time, as long as you're engaging in dialogue with Oscar, that should be not too frightening. Right, this is a slightly more controversial one now. Oscar have been seeking to flex their muscles a bit more, increased inquiry powers and powers of intervention. But again, I don't think people need to be as concerned about it as they might be on first hearing about this. So from April this year, Oscar will have the ability to investigate former charities and former charity trustees and to issue directions to former charities not to take specific action for up to 6 months, where it's with a view to protecting assets that that organisation had built up whilst it was a charity. Under the current regime, Oscar's locus pretty much only extends to someone who is currently on the register as a charity and to existing charity trustees. I am actually quite pleased about this because I've acted for charities in the past where the going gets tough, people, including office bearers, chairs, just go, I'm off. Now, it's understandable. We're doing this in a voluntary capacity. We are not being paid for this. But they leave a few behind who are trying to do their absolute best for the organisation. And there was an inquiry report Oscar did a good number of years ago, and they were quite critical of the decision making of the charity trustees. And I can understand why they did it, but I felt a bit as if, well, wait a minute, these are the ones who stayed. Really, the ones that should be criticised are the ones who just, dereliction of duty, just walked off. But Oscar didn't have any locus over them. So I think people need to be aware now that just because you resign from a charity, it doesn't mean that that's you home and dry. It's a useful one to remind people who maybe want to resign and for ulterior motives publicly lambast a charity that they were previously involved with, say because they've got an interest with another organisation. You do see that quite a bit as well. So I am in support of this change, but something for people to be aware of, and that is from April this year. Another one that's coming in from April this year, and this is the one that's maybe a wee bit more controversial, is the ability that Oscar will have to issue a positive direction to a charity to take a specific course of action. Under the current legislation, most of Oscar's powers are framed in negative terms. So a power to say you can't do this or you can't do X or Y, typically linked to protecting a charity's asset. But here they will be able to say, no, we want you to do X or Y. Now, they don't have carte blanche in this regard. They can, the safeguards around this are they can only do it where they consider there's been misconduct, likely on the back of an inquiry that's been conducted, or when it's necessary or desirable to protect the assets of a charity or to ensure that those assets are genuinely being used in furtherance of the charity's charitable purposes. And the sorts of things they might direct a charity to do is to remove a specific trustee who is clearly acting in a manner that is contrary to the interests of the charity. If the board have been trying to do that but struggling, or say you've got a charity with a very charismatic founding member and they've got all sorts of things written into the constitution to try and protect them, things like that. So the aim is to strengthen Oscar's investigation and enforcement powers. There's not, excuse me, not much more I can say on this at the moment because it's really a case of waiting to see how this will be implemented in practice. One of the frustrations I've had on behalf of clients is linked to the notifiable events regime. And if you don't know what that is, there's not a statutory duty linked to this, but trustees are strongly encouraged to report to Oscar, self-report where there is a situation that's really serious from the point of view of the ongoing survival of the charity. So it could be a safeguarding issue, it could be withdrawal of core grant funding, something like that. You're not legally obliged to report to Oscar, but if you don't do it and then things go a bit wrong, it doesn't look great. But sometimes, again, in situations where trustees have walked off and there's been a bit of shambolic decision making and the one or two who are left notify Oscar of where things are at and sometimes feel a bit, oh, but then I'm not getting any help. This might enable Oscar to provide a bit more help in terms of issuing positive direction. So it's not necessarily something to be scared of. Another 1st April increased power for Oscar is the power to appoint interim trustees. We've already got something similar in the 2005 Act called acting trustees. But at the moment, a charity itself can request that Oscar help with this if the numbers of charity trustees have dropped below the quorum, if there's not an ability for the charities to appoint additional trustees themselves. But this new power will allow Oscar to appoint off its own bat or also on the request of a third party. So say you've got a senior management team like a chief exec The board are in chaos. They're not doing what they're meant to be doing. Half of them never turn up to meetings, and the charity can't function properly anymore. It's the sort of thing you could see a senior management team potentially going to Oscar about. But as with this and the previous power to issue positive directions, take comfort from the fact that Oscar are obliged to act proportionally and only to take action where action is necessary. So again, I don't think at the moment it's anything to be too concerned about. I see it as a positive. So we've looked at information of trustees, more information being published around accounts. We've looked at greater powers of intervention for Oscar, more positive powers rather than you can't do this, you can't do that, we need you to do X and Y. We're now going to look at disqualification provisions. There are already disqualification provisions in the 2005 Act saying here are the situations in which someone is disqualified from acting as a charity trustee. And what the revised legislation is doing is looking at extending the list of grounds for which you're disqualified. So a lot of them currently relate to things around dishonesty and fraud, but we're opening that up also to offences connected with terrorism, money laundering, bribery, perverting the course of justice. There's nothing controversial in there. And the more interesting element, I think, though, is excuse me, this is also now being extended to senior management roles. So if you're disqualified from acting as a charity trustee, you can also be disqualified from acting as chief exec or chief financial officer in a given charity on those same grounds. And this gives recognition to the fact that boards sometimes only meet 4 times a year. As board members, we are meant to be aware of what is going on within the charity. We are meant to have risk matrices and risk management procedures. But sometimes it is senior management who are running the show. And again, if you've got a very charismatic senior management, sometimes boards are sort of rubber stamping what comes to them at board level. So this is recognising that actually senior management have such a pivotal role in the running of an organisation. So if it's not appropriate for you to be a charity trustee, it really would not be appropriate for you to be in a senior management position within the charity either. I mentioned this one earlier. There's now from the 1st of April going to be this requirement for charities to have more than a kind of transient connection to Scotland. So Oscar will be duty bound from the 1st of April this year to reject an applicant to the register where it will have only a negligible or indeed no connection to Scotland. Now, that doesn't mean if you're a charity that's set up here and you're doing a lot of overseas work, it doesn't mean that in the future you can be removed from the register on that basis. It's more looking at whether there genuinely is no connection with Scotland at all. So the sorts of things they look at is, where is your principal office? Is it in Nigeria or is it in Scotland? Do you occupy any premises here? What level of activities are you having here? Are any of the charity trustees going to be resident here, or are they all going to be abroad? To be honest, it was surprising this wasn't reflected in the legislation already. It does apply to SCVOs, because SCVOs have to have their principal office in Scotland, but for any other charity form, they don't currently have to have this real connection to Scotland. So it makes sense to me and shouldn't be controversial. This is a really useful one that's coming in from probably summer 2025, a register of mergers, and I do a lot of work on charity mergers. This is going to be a register that's publicly available on Oscar's website, and it's been brought in really to help with the transfer of legacies. What do I mean by merger? Well, the most common scenario is where you have one charity is transferring all of its operations and all of its assets to another charity, and then it winds up. Or you could have 2 or more charities amalgamating and forming a brand new charity. Either which way, it involves one or more charities being wound up. And if someone's left a legacy in their will to a charity, you need to currently look carefully at the wording of that bequest. If it just says, I am leaving whatever it is to Poppy Scotland, then that's pretty much where those assets have to go. If it refers to Poppy Scotland or any successor charity, you've got more scope in terms of where it goes. But at the moment, what charities have had to do sometimes in merger scenarios is keep a sort of shell entity running on the register so that they don't lose legacies post-merger. So if charity A is transferring everything to charity B, charity A maybe won't wind up for a period of time. It will just sit there hoping to get the benefit of legacies. So there's more admin. It's not an ideal situation. What will happen when this register comes in is that the receiving entity, the recipient charity, the one that's going to be continuing, can notify Oscar of the merger. And it then becomes a quick and easy entitlement for that recipient charity to receive any legacies left to the charity that has been wound up. The only caveat to that is if the person in the drafting of their will made it absolutely clear it is to this charity and no other, then that wouldn't apply. But this should actually be a helpful situation and welcomed by the charity sector. The next one, this is a wee techie one relating to the 42, excuse me, this awful cough, 42-day notice period. So at the moment, there are certain changes that a charity cannot make without Oscar's prior consent. So you cannot change your name. You can make any other change to your constitution you want, but not your objects. Your charitable purposes, your objects clause, you need Oscar's prior consent for that. And any winding up, whether it's in a merger context or otherwise, you need Oscar's consent. At the moment, you need to give Oscar 42 days notice before you make the changes. And the way that's worked in practice hasn't been ideal. So if I'm working with SCVO today and they decide to go global and change it to GCVO or whatever, if they put in their application for consent to change of name today, the 28th of February, theoretically, Oscar, if they're quite quiet, could come back next week and give consent. But they still have to wait the 42 days before they give effect to the change of name by passing the necessary resolution of the members. So it's a bit of a silly situation. So what's now going to happen is you don't have to give that 42 days notice. You need to apply for consent. Once you've got your consent, you can crack on and do the necessary. So it cuts down a bit of admin. And that's taking effect from the 1st of April. Happy days. Charity names. There are some interesting wee changes being made in relation to charity names, and that these are from the 1st of April this year as well. Excuse me. So these are, I'm so sorry about this, honestly. I've had this for weeks and weeks and weeks. Blame the fact that I've got Jeremy children who bring everything home from their school. The first one is quite a specific situation, and it relates to change in legal form of charities. Most commonly where you've got an unincorporated association as a charity. And if any of you are from unincorporated associations, you'll know it's not an ideal place to be. There's potential personal liability for those on the management committee. So very often unincorporated associations want to convert to be a SCVO to get the protections that offers. But you cannot currently have two charities with the same name on the Scottish Charity Register. So as far as the outside world is concerned, they don't really know that you've changed from an unincorporated association to a SCVO. You would want your branding to be the same. You'd want your name to be the same. But what you're having to do at the moment is come up with a sort of dummy name for the new charity. So you apply to Oscar to set up a SCVO. You give it one name. You then transfer over all the assets of the unincorporated association and then wind it up. So for a period of time, you've got both your SCVO and your unincorporated charity on the charity register at the same time. But because they can't have the same name, you're having to come up with this dummy name for the new one and then change it once the old one has been wound up. So Oscar and the legislation is now going to allow you to have, in that scenario, two charities on the register with the same name for a period of time, which is quite helpful. It means you're not having to fiddle about with your branding or anything. Excuse me. The next change relates to known as names or operating names. So Glasgow Life. I am a Glasgow girl. I set that up, again, heartbreak at the passage of time, in 2007. If you're from Glasgow, you'll be familiar with their branding. You can probably see it in your mind's eye. They run the concert hall, fruit market, all the libraries like the Mitchell, all the museums and galleries, the Borough Collection, Kelvin Grove. The world knows them as Glasgow Life. If you go into Company's House, because they're a charitable company, and search up Glasgow Life, you will not find a company with that name. Their legal name is Culture and Sport Glasgow. But everyone knows them as Glasgow Life. Oscar currently only have powers vis-a-vis the formal legal name of a charity. So if it's a SCVO, the name you registered with Oscar on incorporation. If it's a company, the name that appears at Company's House. They don't really have any powers over any separate operating name you have. And actually, the operating name is the one that the public are going to be aware of. So come the 1st of April, they'll have similar abilities to require you to change your operating name if it's offensive, if it's misleading, suggesting you do something completely counter to what you're doing, or if it's too similar to the name of another charity. So at the moment, they can only do some of this in connection with complaints that have been made. Now they're going to be able to do it not just in relation to the formal legal name, but in terms of operational names, which makes sense as well. Some other minor changes, I've not covered them all off because there are quite a lot, and there will be more and more updates coming out in this. We ourselves as a firm have already done quite a detailed update. We'll be doing more and more of this as each tranche of changes comes through. Endowments, this is quite a specific one, really only of interest to sort of royal charter bodies and some bodies that are set up under statute. They were excluded from the regime on charity reorganisations, allowing them to make changes to their governing documents via a charity reorganisation through Oscar rather than having to go to the Court of Session, which is very costly and a bit of a headache. So there's now been a bit of recognition for that, making it easier where you've got endowments held by charities constituted under Royal Charter. So that's quite a specific one. It's not going to apply to many of you. Protection of assets. So I talked earlier about the fact that Oscar's now going to have these new powers over former charities. It always did have a certain amount of power in relation to a charity that ceased to be on the register, whether voluntarily or otherwise. If you come off the register, currently you do not have carte blanche to do whatever you want with the assets that you have built up during your time as a charity. You have to continue to use them for charitable purposes. But what's missed out of the current legislation and what is coming in from the 1st of April this year is this requirement not just to use them for charitable purposes, but to use them for public benefit. You could see a scenario whereby you've got an education charity and you cease to be on the register. I'm going to take a controversial one. Let's take independent schools. So you've ceased to be a charity, and yeah, you can still, no problem, under the current legislation, continue to use your assets for charitable purposes, but you might all of a sudden get rid of any kind of, bursary or scholarship scenario and have it completely restricted to the wealthiest of the wealthy going to your school. From 1st of April to 2024, they wouldn't be able to do that. They would still need to be able to demonstrate public benefit and opening it up to a wider grouping. There's not, technically speaking, a statutory requirement at the moment to submit an annual return, although it wouldn't go down well if you didn't do it. So that's now being rectified in the legislation, that in the same way you have a legal obligation to submit your accounts to Oscar, you'll have legal obligation to submit an annual return. You'll also be obliged to notify Oscar of changes in your principal office. Principal office might be the home address of a trustee if you don't actually have premises. At the moment, you really only have to do that when you're notifying Oscar that you've made certain changes. Like if you're doing a notification of changes made form to say you've changed your constitution or you've changed your name, there's a wee section in it asking about your principal office details. But again, you're going to have to keep them updated on that, which makes sense. Gosh, I'm cantering through this faster than I thought. It might not feel like it to you, especially listening to me hacking away down the microphone. The wider review. This is the bit that I am interested in, and I know SCVO have made some comments on this publicly as well. The Scottish Government have committed to a wider review. You may well ask the question, when they were doing the consultation in 2019 and 2021, it effectively was a wider review then. I certainly fed into that. I'm on the Charity Law Subcommittee of the Law Society of Scotland, and we fed in extensively with everything that we thought should be seen. So all that information is there, but I understand the government are now making preparations for new consultation. And there's not a lot we can do about it. I mean, it's positive that they are doing that, but you do kind of think, well, that opportunity was there previously. There have been calls for it to be headed up independently. In fact, Tracy can keep me right. I think maybe SCVO have been involved in some of those calls. The timetable for the wider review. Yeah, thanks, Tracy. The timetable for it, the last I heard is they are in the planning stage for going out to consultation. There are some techie bits and pieces that are going to come through, not in the shape of a new act, but in secondary legislation and regulations, looking at specific reforms, maybe related to charity accounting, some minor tweaks to SCVOs under the SCVO regulations and around SCVO dissolution as well. But some of the biggies, that's going to be, I think, pushed further on. And one of the ones that I've been banging on about and forever, and it will not be of that much relevance to all of you, but is the conversion of unincorporated associations. SCVOs are the best model in the world. I absolutely love them. And they were brought in specifically because you had so many wee unincorporated charities in the Scottish Charity Register, where those on the management committee are exposed to personal liability, which is a horrible place to be. And that's why SCVOs were brought in. Companies and company law seemed a bit onerous. Here's something in the middle that provides the same protections. Now, there is a dead easy process for charitable companies and something called registered societies to convert to a SCVO. SCVO itself did it. They used to be a charitable company. It's dead easy. They pass a resolution saying, we want to be a SCVO. Here's a new SCVO constitution. And then behind the scenes, Oscar and Company's House have a wee chat and go, right, this is the day it takes effect. And then everything automatically transfers from the company to the SCVO. So you don't do chippy consultations. You don't have to formally transfer leases via lawyers. You don't have to formally transfer contracts. It all just happens magically. That is not the case with unincorporated associations because they don't really exist in law as a separate entity. It's just a collection of individuals. I think when the drafting was being done on SCVOs, it was felt, it's a bit hard to deal with this. So poor wee unincorporated associations, if they want to get that protection, they need to engage lawyers to assign leases and transfer contracts. They need to do chippy consultations. I've been banging on forever that I would like to see something done, and I've been speaking to my lovely former boss, Stephen Phillips, who was the guru of all things charity law and who's now retired. And we were saying, actually, this isn't that hard. You could do this and you could do that. So I would like to see that, but who knows? Other changes, excuse me, I'm so sorry. Other changes I would like to see relate to SCVOs. As I said, I love the model, but there are kind of two groupings of changes. One kind of relates to fundamentals of what a SCVO is. There's this weird anomaly in the SCVO legislation that the members of a SCVO, not those on the board, not the trustees, but the members have a duty to act in the interests of the SCVO. Now, I don't have a problem with it per se, but you don't have that for other charity legal forms. So for a company, if you're a member, you can vote any which way you want. If you sit on the board, absolutely not. You have to always vote in what you consider to be the best interests of the charity. So if you set up a charitable joint venture, say like the urban regeneration companies in Scotland, like Riverside, Inverclyde, Irvine Bay, Clyde Gateway, they would have a council as one corporate member, Scottish Enterprise as another. But when they're voting on changes to the Constitution, Scottish Enterprise can vote entirely how Scottish Enterprise wants to vote. I'm not saying that's the right thing, but it just seems weird that if you set up a SCVO, your members, who probably pitch up once a year at the AGM if you're lucky, have these legal duties to act in the interests of the SCVO, and it doesn't apply to other legal forms. There are other slightly weirdy features of SCVOs in that only natural persons can set them up. So Tracy and I could set one up, but SCVO couldn't itself go and set up another SCVO so I did this with Leisure and Culture Dundee years ago. Dundee City Council wanted to set up a SCVO rather than a company because a SCVO is just a more streamlined, better model. But you had to set it up in the names of individual staff members, first of all, then admit the council as a member, and then the staff members kind of fell away after that. So it's just a weirdy one. I know ALIOs are not always massively popular in the sector, but just from a techie point of view, it's quite interesting. And then there are actually wee random techie things relating to scales that I have no idea why the opportunity wasn't taken to update them as part of charity law reform, because they're not contentious. So the legislation in SCVOs came from taking the most relevant bits of company law, because huge sections of company law are not relevant to third sector bodies, but there have been updates in company law that haven't been updated. And with SCVOs, for example, the thresholds for passing a resolution in writing by the members, so there's a higher threshold for SCVOs than there is for companies. So things like that, it could have just simplified things a bit. I'm not really sure why that wasn't done. And I promise I'm about to finish. I'm not going to go through this, but I've just at the end of the slides, which you can peruse at your leisure, grouped the changes in terms of April, October and summer next year. And then I've got my email address at the end, which is very, very long. If you ever want to just, well, Tracy and Rhonda have obviously offered their excellent services, but if you're ever wanting to email me directly and just ask a few questions. Tracy, I think I've stopped sharing, have I?
You have, yeah, but your camera's still off, so I don't know if you want to put that back on.
I will try. You can watch me coughing instead of just listening to me coughing.
Thank you, Gillian. That was really informative and I think reassuring, actually, because I think a lot of charity trustees are maybe worried about some of these changes. So I think you've provided that reassurance. There's a couple of questions, not as many as I thought. So obviously your presentation has been a good one.
I've coughed them all away. They've all gone.
One around the interim trustees, which, you know, myself and colleagues within SCVO have been discussing as well. You know, how is that going to work? Who's going to do this? Charlotte had asked a question on, you know, what person would Oscar want to take on as an interim trustee? You know, how do you think that's going to work in practice?
I don't know where they're going to find them from, to be perfectly honest. It's not really happened very often with the acting trustees, as far as I'm aware. So Oscar would really be best placed to advise on this, but given that we struggle, those of us who are on boards, to get board members anyway, where this magic pool of interim trustees is going to come from, I'm not entirely sure. You would imagine it would probably be people from professional backgrounds, maybe like charity lawyers and accountants. But yeah, a lot of this, I'm afraid we just have to wait and see those kind of test cases, those initial ones of how it will operate.
Yeah, yeah. And maybe not something that they would use that often, but
oh, I don't think so. I think it would be, like I said, they're only meant to act where there really is a need for them to act. They'll be finding their way with all of this, as will the rest of us as well.
Yeah. Yeah. Okay. Thank you. Patrick had asked a question about the advantages of SCVOs, but I think you've covered that anyway.
Oh, Patrick, that's a whole other topic. But yeah, they're generally awesome. In about 5 seconds, Companies Act is this thick. If you can see me, you could kill a man by thumping him over the head with it. Most of it is not relevant to you. It can trip you up. So if you are a charitable company, a criminal offence is committed if you do not notify members of the right to appoint a proxy at general meetings, but no one's ever been to jail for it or fined, so I wouldn't worry about it too much. SCVOs, it's all the relevant bits, and the legislation is about that thin. That's not to say that they're not properly regulated. SCVO constitutions, there are lovely examples on SCVO's website. They're much easier to follow. You dump all the jargon. You've only got one set of duties on the charity trustees from charity law, not the Companies Act duties as well, where there's crossover, but they're not quite the same. So it's a lovely one, but there's more information on SCVO's website on SCVOs.
Yeah, and Patrick, if you want to contact us direct, we can send you a list of the pros and cons. There's a question from John, Gillian, on for charities that cover the whole of the UK. Are there similar changes in England and Wales? You know, what's the difference between the regime there and what?
Yeah, the legal system is not. There are similarities. They're not entirely in sync on this. It's quite a big topic. I can't tell you all of that here, but what I would urge you to do is there's a law firm I work very closely with called Bates Wells. They're in London. They are the absolute best of the best south of the border. They do a wonderful weekly briefing, and that also covers Scotland actually. I would sign up to that, but they've done a whole series of updates to the Charities Act 2011 and what things are coming into force and when they're coming into force. The register of mergers I talked about is a concept that's actually come from English charity law, so it's not going to be identical up here, but they have wonderful resources in terms of their briefings and insights and things like that on their website. So I'd have a wee look there.
So that's Bates Wells. Yes, they are very good.
They're awesome.
There's quite a specific question from Volunteer Scotland in terms of updating articles to ensure compliance with the Act. I wondered more broadly, can you say, does this mean everybody's going to have to update their constitutions?
No. Most of this is like you don't have to include anything in your constitution saying we must now notify Oscar of changes in trustees. The constitution's more of an internal document, stuff around automatic disqualification of trustees that will already in most constitutions just refer out to the legislation, and the legislation you refer out to is the 2005 Act, and that is still going to be the Act. Most constitutions will also, if they're drafted properly, when they refer to legislation, they'll say as amended from time to time. So if it refers to the 2005 Act, it doesn't mean the 2005 Act now. It means the 2005 Act, every iteration of that in the, excuse me, in the future. So no, I wouldn't imagine much in the way of change to constitutions.
Great. Okay. And just going back to that disqualification, I had wondered if you're including senior management in that, is there going to be some kind of overlap with employment law there? Will that potentially be retrospective? How do you actually see that one working? I know it's difficult to say, but
a good question, actually. I mean, it will apply to a given charity, but yeah, it is actually a very good question. And I'd said to some of my employment colleagues, we need to get our heads together and have a bit of discussion around how this is going to work going forwards. But I suppose the sorts of things that preclude you from being a charity trustee, a lot of them are criminals. So there would be things for which someone would lose their job anyway in an employment context. So I can't imagine anything in the charity law changes is going to cause a major issue from an employment law perspective. There's also the ability to apply to waivers for from some of the operation of that with Oscar, or say, okay, well, I want to have a role in the charity doing this, but it won't include finances. So say, okay, you can do that bit, but not this bit.
Yeah. And I think probably that will be important for people, if you want to get lived experience on board, maybe ex-offenders, that kind of thing. There is going to have to be some
Again,
around that.
I think, and actually there's been one in the news this week of a former teacher who had committed an offence in terms of a relationship with a pupil, and she's looking to, this is all in the public domain, she was setting up a charity that was going to be working with ex-offenders. So some of that, again, it depends on the role that someone is going to have, and there's a distinction in terms of spent convictions and unspent convictions. So there's a lot of detail in the legislation if you can find the time to look at it, and also look at the explanatory notes at the bottom of the 2023 Act are very helpful. I maybe wouldn't bother now. It's going to be easier for you when it's all incorporated into the 2005 Act. At the moment, if you're looking it up, the 2005 Act is as it stands now. So you're having to cross-refer with this 2023 amending legislation. But once come the 1st of April, the 2005 Act will look different. And then it'll look different again come the 1st of October. And then some on the specified date in summer next year as well.
Okay. I think probably we'll be doing more webinars like this as well as we go on with the updates. Yeah. There's a question about that connection with Scotland. So Can trustees, can you only have maybe one trustee living in Scotland and the rest would be overseas? What does the connection need to be?
So it's not specified definitively in the legislation, and it's not even like an exhaustive list of factors. It will be very much on a case by case basis. If you had one trustee, I don't know, it would maybe get, I think it would be difficult if you're not ever having meetings here. But if you had one trustee here, but you had staff here and you were actively doing things on the ground, that might be different. Although I would tend to say from a governance point of view, if most of your trustees are abroad and you're only ever meeting on Teams, that's not necessarily the best, because you get a different Teams and Zoom and all the rest of it are great, but you do get quite a different sense and dynamic in discussions when people are actually physically, excuse me, in a room together, around a table together. So Oscar would make a decision based on all of the factors. What it maybe wasn't clear from what I was saying, it's not just that they can refuse to register someone from 1st of April onwards who doesn't have that connection. They can also look at removing people from the register who are currently on where there's not that connection. But it's not intended to stop predominantly overseas activity.
Okay, great. We're running out of time, and I would say to people, if we haven't answered your questions, please do get in touch with us, the information service. My colleague will put the link in the chat for that. And who knows, you might get to speak to Gillian directly on our free legal advice service.
That would be.
I'm going to
I'll try and get into the cough.
I'm going to give you one last question, Gillian, just because we are running out of time, I think, because there's questions they're about audit thresholds. There's more questions about SCVOs, and I am mindful that I think we should do a webinar on SCVOs. There is a lot of questions around that.
Audit thresholds, there's going to be other stuff coming around that is not covered in this legislation, but I know that is something that is being separately looked at, and I've just joined the Institute for Chartered Accountants charity panel, so I'm upskilling myself in that, so I will know more about that as things progress.
Yeah, and I think as SCVO, we are aware that some organisations have had difficulty accessing auditors, costs of audits, all of that. So if you want to send your question in about audit thresholds to us again, that would be fine. We can take that one. But I'm just going to finish off with one more question before we wrap up. And Heather's asking, you said about the protection of assets. And how would you define public benefit as they brought that extra piece in?
The same way it's defined in the charity test currently. So the charity test currently, you must have only charitable purposes in your constitution, and you must deliver public benefit. And when Oscar are making an assessment on that, say you're setting up a new charity, they look at a range of things. They look at the range of beneficiaries and to what extent there's private benefit and the balance between public and private benefit. These are quite, I'm trying to think, maybe the best way of giving you an example. So I talked about urban regeneration companies earlier. They are charities. They are set up to deliver regeneration projects in maybe former dockland areas and things like that. The urban regeneration companies have all set up wholly owned non-charitable trading subsidiaries because some of the activities they get involved in, it's borderline whether or not they benefit the public. So if you've got a disused dock and you think, right, we're going to make this look really nice, we're going to put up housing, attract young professionals to the area, put up a community hub, all the rest of it. On the one hand, you could say that's delivering public benefit and furtherance of the charitable purpose of advancing regeneration. On the other hand, for these companies to do this, they've entered into joint ventures with private sector developers, and there's a lot of private benefit accrues to those developers. So the decision at the time in setting these up was the balance is maybe not quite right. So we have to route that through a non-charitable entity. Similarly, if you're a charity that's, well, let's go back to the private schools. I always hesitate to mention that. But if you don't have scope for anyone out with the kind of those who can pay for it to come in, you're arguably not delivering enough in terms of public benefit. Some charities deliver training and bespoke training programs to private businesses like law firms. Is the private benefit there going too much to the law firm? So it's the same kind of assessment. So but in this case, where it's protection of assets, if you start to use those assets for a more limited grouping of individuals or bodies, and there's not that kind of sense that you're targeting a large-ish section of society, that's the sort of thing they would be looking at. I mean, you could theoretically have a charity, lose your charitable status, and convert it to some sort of family-based company, because some are set up by kind of a key founder with their husband and children involved somewhere in the organisation. I don't know if that answers that very well. Sorry.
So it would be probably a case by case basis, wouldn't it? Thank you. We've run out of time. There's loads and loads of questions. So I think what we'll do at SCVO is take a look at them and see if we can answer them. I would like to highlight, we've got a new charity law information pages on our website. We put the link in the chat. It's under the legislation and regulation pages on our website, and I'll send out the link in the email that follows this as well. And just to say, we will be updating this as we get more information from Oscar on the implementation of the Act. So that'll be the best place to go, other than Gillian's updates on the Anderson Strathern website. So
yeah, you can follow me on LinkedIn. I always put stuff on LinkedIn as well, if anyone's on it.
Brilliant. So it's just after 2. So thank you all for coming. I hope you've been informed and enjoyed this as well. And do look out on our events pages for more webinars, not just about charity law updates, but other things as well. And thank you all for coming today. Thank you.
Thank you.
Thank you.